The Nuremberg Forum 2024. And now that panel 2 has given us such an intricate assessment of the rights framework protecting children in armed conflict and its achievements and shortcomings, panel 3 will move on and look at prosecutions and the best strategies and experiences defining such prosecutions in this context. The panel will be moderated by Dr. Gurgen Petrossian, who is a senior officer for international criminal law at the Nuremberg Academy, responsible for the Academy's research work, and whose work was also influential in Armenia's recent accession to the Rome Statute of the International Criminal Court. So thank you, and over to you, Gurgen.
Thank you, Kiran. Welcome to our next panel on strategies, prosecutorial strategies against crimes against children. I'm very much happy to have panelists with me, distinguished panelists, experts in their fields. Before we dive into our discussion, I would like also to cover some logistical issues. The panel will last 90 minutes, during which each panelist will have 2 minutes of introduction. And following that, we will engage into our discussion on the topics. The final 30 minutes is, of course, also given to you. You will have the chance to ask the questions to the panelists. So please use that momentum to address your questions either here. You can see here the microphones. Please use that to address your question, of course, or virtually. You have the QR code on your brochure. Please, you can just send your questions anonymously. So we are fortunate to have gathered a group of distinguished panelists, said each experts in their field, and we are going to address especially the crimes against children and the strategies and the experience that we have collected through the prosecution activities. Well, the impact of witnessing such horrors affects, of course, children throughout their lives and can be passed down within the families. And I recall the stories of my grandfather, whose father was a victim, and as a child was a victim of Armenian genocide, and had to flee from the Ottoman Empire. And these stories were told me when I was a child, and I'm sure the stories, well, I will tell also to my children when I will have them. However, well, these narratives are etched in the family histories. As soon as those children grow, this trauma remains, as we have already discussed in our first panels. Children are particularly vulnerable to the perception of these events, making the need for a focused discussion on their experiences all the more essential. So, as said, we have here different perspectives. On my far left is Véronique Aubert. She's a lead on children and armed conflicts at the Save the Children. She's a special advisor on crimes against and affecting children to the ICC Prosecutor. She's senior human rights expert with over 20 years of experience in fact-finding missions, investigating gross violations against children in conflict settings, and promoting governments and armed actors' compliance with international law standards. Ms. Aubert has also co-authored an important policy for the ICC on children, policy on children. On my left is Judge Luz del Carmen Ibáñez Carranza. Very honored to be here and to be moderating this panel with you. She has served as a judge in the appeals division of the ICC since 2018. Prior joining the ICC, she served as a senior national prosecutor in Peru's specialized system for the prosecution of crimes such as terrorism, grave violations of human rights, and crimes against humanity. Thank you for being with us here. On my right is Dr. Serge Brammertz, Chief Prosecutor at the UN International Residual Mechanism for Criminal Tribunals. Mr. Brammertz has also served as a Chief Prosecutor of the ICTY from 2008 to 2017. He oversaw the arrest and prosecution of key political military leaders of the Yugoslav conflict. And on my far left is Natalie von Wistinghausen, Victims Counsel at the ICC. Ms. von Wistinghausen specializes in criminal law as a trial advocate and has acquired wide-ranging legal experience in domestic and international legal criminal work. So as you can see, we have here a prosecutorial perspective, judicial perspective, NGO perspective, and victims counsel's perspective. So without furthermore delaying, we move to our opening statements. And I would kindly ask Ms. Aubert to give the opening statement. Thank you.
Thank you very much, Dr. Petrossian, and thank you to the Nuremberg Academy for organizing this conversation. It is true that it has been several decades that I've been trying to promote the advancement of justice for children, and so having this conversation with such established expert in this historical place is so important. I was reflecting on my way here about the early 2000 years when I was documenting for Amnesty International the widespread crimes that were committed in the Democratic Republic of the Congo. And I was just remembering how at the time my colleagues and I engaged very closely with the newly established International Criminal Court, and actually Serge Brammertz, who I'm very happy to share the panel today, was the recipient of a lot of pressure, demand, request on our part. And of course, to me, one of the landmark moments was the 2012 conviction of Thomas Lubanga. It's been mentioned a few times. Key moment where the ICC held armed groups commander accountable for forced recruitment and conscription of children. This trial, and we were discussing yesterday how it was broadcasted in middle of Bunia through some magical electricity measure, it did have an impact at the time. And it sent a clear message that those responsible for recruiting children must answer to international court. And really, along the before, during the investigation, and after, throughout the whole 10 years, I do think that these put pressures, including on armed groups, and although not eradicating totally the recruitment and use of children, it did help prevent the recruitment of at least the youngest children, and that was very noticeable. And therefore, that gave me a real sense of how justice can serve as the deterrent. However, the Lubanga case also exposed key challenges, particularly in dealing with children testimonies. And one of the unintended consequences was a reluctance to use child witnesses in future cases. And it was in response to that that the first ICC children's policy was developed in 2016 under the guidance of Special Advisor on Children affected by armed conflict, Diana Mann, and to which I had the honor to contribute at the time. And this was, I think, the first public document produced to try to ensure justice for crimes committed against children through international justice. This policy was a real milestone, and since then there have been significant and sustained progress regarding the inclusion of reference to children in foundational document of international accountability mechanism. However, how it's been discussed since yesterday, children access to judicial and non-judicial mechanism has been very much overlooked. And therefore, it's been a great honor to collaborate in my role as Special Advisor Crimes Against and Affecting Children to the ICC Prosecutor, to collaborate with the wonderful Kim Sillinger, who's been a fantastic writer between us of the children policy, and with the hope that this document will provide further strategic direction aiming at improving how cases involving children could be investigated and prosecuted. And so I'll be very keen to discuss some of these aspects of this policy during the discussion today.
Thank you very much. Judge?
Good afternoon, dear participants, ladies and gentlemen, and excellencies, and all the audience who is following us through online. Thank you, dear Gurgen, for the floor, and thank you to the Academy for organizing this flagship event on such important topic and for inviting me to participate. Well, children are the most vulnerable victims in armed conflicts and often endure such atrocious crimes such as genocide, crimes against humanity in diverse forms, inter alia, forcible deportation, persecution, enslavement, trafficking, sexual violence, gender-based sexual violence, and also war crimes that include forcible transfer, displacement, starvation, etc., which harms them profoundly and have devastating consequences in their life. So, from my perspective and experience of more than 35 years as prosecutor in my country and more than 6 years as international judge at the ICC, I can tell you truly, prosecuting and adjudicating real justice for crimes against children is really, really a huge task. It's a very difficult and challenging task. And we can have several factors. I could number some of them. For example, we have troubles with legal characterization, with gaps of impunity. In terms of Rome Statute, Articles 8, 2b, 26, 8, 2e, 7, they do not cover extensively all the means of protection for children envisaged and stated in Article 2.2 of the Convention on the Rights of Children, nor does the solely article in the crime of genocide. We don't say nothing in the Rome Statute about sexual and gender-based crimes directed exactly against children, as some of the crimes we are being adjudicating in the ICC can show us. The issue started in Nuremberg, actually. Well, other challenge is in terms of harm and damage. For example, for the issue of child soldiering, we are not able, in terms of correct adjudication, to determine exactly what kind of damage, specific damage, do these children suffer. In my view, the most terrible thing is, of course, there are moral damage, there are material damage, etc. But the most terrible thing is that they lose their project of life and the future perspectives. And we are not, until now, capable of exactly giving a meaning or a sense to this kind of damage. There is also the issue of transgenerational harm that yesterday someone spoke about. The transmission of trauma from one generation to another generation. We are just working on this. In terms of the scope of victimhood, we also have a lot of problems. Moreover than direct and indirect victims, what about of the offspring born out of rape or victims of transgenerational harm? In terms of a special kind of victim, that is the case of the victim perpetrator, those who were victims as children and now perpetrators as adults, from which the case of Dominic Ongwen is a singular case. We have issues with victim participation. We use victims, children, as witnesses, but they are also victims. What are we doing about this? So it's a very difficult situation there. We have problems with reparations, specific reparations, effective reparations, targeting the specific damage. So the challenges are numerous. So I'm happy that we are here this afternoon to issue and to discuss and to try to advance some developments in terms of that we can have a better adjudication in crimes against children. Thank you.
Thank you very much, Judge. Prosecutor Brammertz, please.
Thank you very much. Good afternoon, everyone. Pleasure seeing you. Last night at the City Hall, I was asked by a group of students, how did it happen that you became a prosecutor? It's a quite traditional question we are getting when you're getting older by the new generation. And I said, well, it was for me personally a very easy decision because as a child, as a teenager, I wanted to become an investigator. And for my first classes of criminal law, I knew at 18 I want to be a prosecutor. So when I turned 26, which was at that time the minimum age in Belgium to become a prosecutor, on my birthday I applied for the first job available. I became a prosecutor at 26, and that's the only thing I've done professionally in my life since then. And then I was asked, what is it doing to a human being dealing for more than 30 years with the dark side of humanity? And it's true, as a prosecutor, the biggest frustration is we are coming in when it's too late, right? When prevention has failed. Well, all the work we have discussed this morning, and we will discuss for the next 200 years, when prevention has failed, the harm has been done, and crimes have been committed. So my simple answer was, yeah, it's true, I'm doing this for 30 years. And I said, well, you are getting used to it. But it was not really, I think, an honest answer, because I've been on many crime scenes as a young prosecutor, as an older prosecutor, and at the international level. And when it's about crimes against children, you can never, ever get used to it. Physically, it impacts you because you intuitively understand there's absolutely nothing which can justify violence against a child. That's why I'm very, very happy that we have this topic as the main topic this year at our event. But I'm also not too optimistic, knowing that if we look at the world today, of all the conflicts, children are the main, let me use the term, collateral damage. And reality is that impunity is the rule and accountability the exception. Now, as I said, I worked at the domestic level. I worked then at the ICC, it was already mentioned, working on the Lord Resistance Army cases, having this terrible analysis of cases where someone who is a child living in a village being abducted, influenced, manipulated, drugged, becoming a perpetrator. Where is the victim ending? Where is the perpetrator starting? The Lubanga case was also the second investigation at the privilege of being involved in, and it was extremely difficult. Anyway, for the day today, I want to speak later on a bit more about the 250 cases ICTY and ICTR have done, in many of them with thousands of children victims. I'm looking forward to say a few words about it, and to speak about the achievements, but also where we probably could do better if we are looking back. Thank you.
Thank you very much. Ms. Natalie von Wistinghausen, please.
Yes, first of all, thank you to the Academy for inviting me. I'm definitely learning a lot, because I have to disappoint you from the outset. I'm not an expert on children's rights at all, even though I have worked as a criminal lawyer over 20 years and about the same time in international criminal law. And I think this is maybe what I can contribute. Why is that so? What did I observe? And how, as a legal representative of the victims in the Darfur case at the ICC, I still try the children's voices to be heard. Of course, for the reasons we all know, securing evidence about crimes against children is not easy, surely not in a national context. It could be easier in the context of an armed conflict and an attack on a civilian population, because men, women, and children are equally affected. I thought it was interesting to be reminded this morning by Professor Skelton that children are always civilians. I mean, of course, we know that. But it's important, I think, in the context also of what we are discussing, and it may also be one of the reasons why actually, at least during the proper criminal proceedings, the focus is not on the children, but that doesn't mean that we don't speak about children and that children's, I wouldn't say rights, but at least like circumstances affecting children can still be at the heart of what's going on in the courtroom. The word child or children, I was astonished, is mentioned only 4 times in the crimes described in the German Code of, against international law. Same in the Rome Statute. So that also shows it's not a lot. The focus is not there. The children are mentioned in the provision for genocide, for enslavement as a crime against humanity, and in the context of being a child soldier. So the latter, like obvious, but in the provision, for example, for enslavement, said enough to have to say that indeed we live in a world where children can be victims of enslavement, and I can speak a bit later about a German case where I represented a Yazidi survivor and her 5-year-old child. I'll keep it there, Gurgen, for the moment, and I hope I can still contribute to the conversation.
Fantastic, thank you very much. So you made already some points, very important points in your opening statements. And the first question that I have, especially to Ms. Aubert and Ms. Natalie von Wistinghausen, we were actually all children once, and we were experiencing also sometimes some injustices in our daily lives. And it's important to maybe look from the kid's perspective and to understand what actually justice means for a child. So I would like to know maybe your perspective, especially Ms. Aubert, your perspective, as you have worked so long for the Save the Children, so much experience you had with children. Can you tell us what the children expect when they see injustice?
Yeah, I mean, I think you have been asking, why. And especially in the context of international justice, why is it important to prioritize children? It's a really good question, because everybody has a sense and intuition, but actually Save the Children produced with Oxford University a very thorough research called Advancing Justice for Children, where we really tried to spend many years analyzing why this is not happening, what the barriers were and are, and trying to make recommendations. In terms of our conversation, this has been floated on a few occasions, and there is, to me, many reasons why children should be prioritized, but I will summarize into 6 key ones. First, an obvious one, but I was really reflecting yesterday during the opening session, how just like through the sophisticated system established in Germany, international justice must also acknowledge the wrongs and atrocities that children have suffered and are suffering. As you've been mentioning, we've all been victims of injustice, and so in the domestic system there is expertise and experience developed to address these wrongs, and therefore the same should apply in international context and justice. Second, it's been mentioned, Anne Skelton and others have articulate the child rights to participate in justice processes that involve them. They are stakeholders in justice. Third, because of their participating in this process can actually be empowering and even healing for some children. And I think the missing actor in this discussion is to actually have a former child or a child who could actually explain what where the gain in being able to participate, on the international system, it's very rare, but in the domestic system, there is many more expertise and experience, children who have gone through the process and how these processes have helped in terms of healing, getting a step closer to remedies and reparation, and how accountability provides some sort of appropriate response to the harm. Fourth, as I mentioned with the example of recruitment of very young recruits, the fact that justice can serve as a deterrent, help break cycle of violence, and support the rebuilding of peaceful societies based on the rule of law. Fifth, because international justice has, as we've mentioned all along, taken an adult-centric approach. And that's, I think, we've all come to the understanding that means that crimes committed against children have been addressed as part of broader crimes committed against the civilian population in general, and that at the heart of that is a problem of limited age disaggregated analysis. And through age disaggregation, there is a lot that can be clarified and analyzed. And the sixth and last point is because children are often unsituated, as we would like to define them in international justice, and simply viewed as a collectivity of non-adults, then their experience is really often treated in a reductionist way, with gender stereotypes often happening with some focus on boy considers our primary victim of the recruitment and use as soldier in hostilities with girls coming only into context of sexual violence, and therefore a misinterpretation of a gender victimization across a much broader range of crime that can be committed against children of all genders. Thank you.
Thank you very much. Miss Natalie von Wistinghausen, you have represented a mother of a child who was actually killed. And of course, with the victimhood also goes to the parents. What were the expectations in that particular case, as you were representing them before the German court? What did they expect from you and from the German justice?
Well, as you can imagine, that was a very difficult case. And this is why it got so much attention. And maybe just to give some context for those who may not know, it's a universal jurisdiction case in Germany against an ISIS member, a couple actually. It was two different trials. They were tried separately for procedural reasons. And they enslaved a Yazidi woman, my client, together with her 5-year-old child. And they spent several weeks in that household, and by way of punishment, and I spare you the details because they are too cruel, the 5-year-old child died in the sun in the courtyard. So the child is dead, the mother is alive, so I can only say what she expected from the trial. And it's actually the same for all my Yazidi clients, but also for my Darfuri clients. When they speak about their expectations of a trial, they speak, of course, of the wish to tell their story, their own story. They want the rights for themselves and their family, but they always see the broader context. They always speak about their community that was destroyed, their culture that was destroyed, the long-term consequences of the displacement. In this very specific circumstances, you have a mother who had to watch how her child died. She could do nothing about it. And I think if it wasn't for her only remaining son, with whom she is here in Germany, she wouldn't want to live anymore, which which I suppose is understandable. So it's really a terrible trial, but this is not what we were talking about here. It's really the focus, I would say, on this trial is exactly because of what you said, Serge Brammertz. When a child is a victim, it's just unbearable, and it gets the attention it deserves. So, what kind of a difference did it really make in this trial that the victim was a child? I would say, in relation to the prosecution and also the conviction for the international crimes, it didn't make a difference because the mother was a slave as well. So we secured a conviction for the religious and gender-based persecution as a crime against humanity, and in the trial against the man, he was also convicted for genocide. That was the first conviction for the genocide of the Yazidi worldwide, and of course, at the basis of the facts before the judges was the killing of the child. So maybe without the killing of the child, there wouldn't have been a conviction for genocide. So of course, you know, that's a big success, if I may say, but we have a dead child. So it's, you know, I mean, it's not as if one could be happy, if I may say, to secure such an important, of course, conviction for the Yazidi community, but the facts, of course, were terrible. Where else did it play a role? In the decision for compensation. We asked for compensation. Unfortunately, we have a jurisprudence before the higher regional courts that's very different from one to another. Some grant compensation in these kind of trials, others don't. But in that very trial, the mother was granted a compensation to be paid by the accused. So of course, we don't know if she will ever get anything. But part of the amount she was granted by the judges, the mere fact that her child died and then she had to witness that, of course, played a role. Where do children play a role in these cases is also actually from a completely other perspective, is where the accused, and most of these ISIS trials were against women who traveled to Syria and Iraq and who married ISIS fighters and who either brought their children with them from Germany or had children there and stayed there for many years. So some of them were also prosecuted for the violation of their duty to care, for having brought their children in a country at war. And lastly, I wasn't involved in these cases, but I just reviewed the jurisprudence where children may have played a role. There were 2 cases where the accused were also prosecuted for the war crime of sending their children to training camps. Right? I don't know the details, but I know that there were convictions. Maybe Ms. Kmel can say more about it tomorrow. I always say I can only speak about my observations because I spend a lot of time in the courtroom, and of course I deal with my clients, be it on the defense or on the victim side. But sometimes when you ask yourself these questions of why is there no focus on children, I just want to say this last sentence. I think that it may also play a role, and I may be contested, that prosecutors need to make choices of what they will prosecute because they want to be sure to be able to prove their case. And there is very little international jurisprudence regarding crimes against children. And a prosecutor and a judge will want a conviction to stand on appeal. So why include crimes against children if there is enough evidence to secure a conviction for other crimes? This may sound a bit provocative, but I'm just saying what I'm observing because, of course, it's at the prosecutor's discretion what he or she wants to prosecute. And I think that this aspect also plays a role.
Thank you very much. So now turning to the prosecutors, perspective. The ICTY, for example, was one of the first tribunals after the Nuremberg that tried to collect experience with the victims. Mr. Brammertz, what kind of challenges you've experienced at the ICTY? We know that the children as such, they were not considered or testified at the ICTY, but considering also this point that Ms. von Wistinghausen mentioned, making the choices, could you share us your experience from the International Tribunal perspective on that?
Indeed, as we all know, one of the big differences between the ad hoc tribunals and the ICC is the non-participation of the victims as such, even if I have to say that at the two ad hoc tribunals there have been more than 5,000 witnesses coming forward, and interacting with survivors and victims has been always in the center of our debate. You were speaking about expectations by survivors and victims. You know, I have on my desk in The Hague a book I got, and I'm sure our colleagues from Bosnia-Herzegovina know it, a book I got from the chairperson of parents of children killed by snipers in Sarajevo. It's a quite impressive book with the mini CVs of all the children, more than 1,000 killed, pictures of the children, the location where they have been killed, and a very short CV, right? It's really quite awful. And so every time I have visitors, sometimes from the political or diplomatic corps, who are saying, you know, it's 30 years later, it's not time to really turn the page and to look somewhere else. I'm always putting this book in front of them saying, look, the parents of those children are still waiting for justice being done, and expectations of survivors and victims are still extremely important. And while we are speaking, we are still working with prosecutors in Sarajevo to prosecute a number of cases related to snipers, because indeed there have been relatively few cases which specifically went on the child-related issues as a victim. Having said that, if you look at the more than 250 cases, in the large majority of those cases, children, victims have been very much in the center and part of the proceedings. If you look at the dossiers in relation to Rwanda, well, the babies, children, pregnant women being killed, hacked into pieces, was only based on ethnicity, where it was very clear that children were very much targeted. If we look at the former Yugoslavia, as you know, in the Karadzic case, Mladic case, and many others, the genocide in Srebrenica was very much related, directly linked also to the killing of young boys. And we were speaking earlier, or you were speaking earlier today about age, when is an individual a child and when is becoming an adult. As we know, even if one argues sometimes that the main victims in the conflict in the former Yugoslavia were men of military age, well, we have seen that young boys, young as 12 years, would be executed by Serbian forces because they were considered military age, or someone looking older than his real age would also be assassinated. So we have seen, obviously, children targeted in both conflicts massively. From prosecutor perspective, what was important was that it has really helped us proving criminal intent, right? We all know that if you speak about military operations, military conflict, people are saying, well, you know, this is collateral damage, or we were only targeting soldiers. Well, if we take, as I said, the assassination of babies, well, it's difficult to argue that this is not a deliberate act. And if you have snipers in Sarajevo who were targeting mothers with children going to the market and targeting the child, or had we had in a number of cases, targeting the mother and the bullet going through the mother, killing the child, it's absolutely impossible to argue that this was a military operation. So the fact that we could prove a very strong specific targeting on children allowed very much and much more easier to establish the genocidal intent and to very clearly establish that, or the genocidal intent, or to establish that those were crimes against humanity and genocide.
Thank you very much. Judge Ibáñez Carranza, you were also prosecutor in Peru. And as far as I'm aware, you were also prosecuting different members of the armed groups and terrorist organizations. Of course, the children were also a central part of those cases. Can you give or share us your experience on the national level, on the Peruvian level?
Thank you for the question, dear Gurgen. And thank you for allowing me to just share some experiences we had in national jurisdictions as in Peru. One thing I can tell you that this kind of crimes, the crime of child soldiering and other crimes against children in national jurisdictions such as Peru, we are not even aware. And the children are not aware even that there is a crime against them. Let me share with you a story of one children that was a child soldier and then became an insider. Let's call him Ivan. Ivan was a son to parents who were like middle leaders in Shining Group, the terrorist organization, the bloodiest terrorist organization in my country, Shining Path, Sendero Luminoso. And he grew up, and he was grown up as a child soldier. He never knew any other thing more than being in the camp, going to see hostilities first, and then to participate in hostilities, and then being sent to the villages to buy some livestock for the leaders or some munition or whatever. So he was used in any kind of activities to support also the terrorist organization. Now, at some point, he got tired of this life, and he managed to escape. He was 16 years old. He escaped to another town in the coast, actually. He came from highlands to the coast, and then he was at that point 17 years old, and in my country there was a law at that point against terrorism which punished children from the age of 16 onwards for crime of terrorism. So in the coast, he was caught, and of course he was prosecuted, he was tried, he was convicted, and he was sentenced to 10 years of imprisonment. Now, in 2005, when I was the prosecutor, I was prosecuting Abimael Guzman, the leader of Shining Path, and all the leader group of Shining Path. I called him as an insider because he managed to get some agreement with the government. He started to collaborate, and his sentence was reduced. So he came to the courtroom. And he spoke a lot from the inside of the organization. He indeed corroborated all the charges, and also he shed light about abuses we didn't know. For example, that he regarded how the leaders, especially the number 3 of Shining Path, called Feliciano, had a bodyguards composed by girls of 16, and used them also for sexual abuses and activities, pregnant them, and forced them to abortions and to physical mistreatment, etc., etc., etc. But he never referred to him as a victim. He never had this sense of this meaning that he was abused, that he indeed was a child soldier, that he indeed was obliged to endure all of this violent environment during the first 16 years of his life. The state wasn't aware as well, because we had laws, that time was the time of Fujimori, that on the contrary punished boys, punished children like him, because, of course, he participated in hostilities and et cetera, and et cetera. So this is a huge problem. I mean, when I met him, he was 23 years, he was in the measures of protection because he was helping the justice. But for me, it was even impossible to ask to him more than what you suffered, because, of course, in a spontaneous manner, he got an account of his life in the camps, in the terrorist camps. But there was that sense that he was not aware, the society was not aware, the state was not aware that there was a horrendous crime against this child and against other childs in my country. And that brings me to a second point. Years later, when I was, of course, the national coordinator of this specialized subsystem to prosecute this kind of crimes, we managed to make operations, special operations with the military, and to go to the terrorist camps to rescue small children that were in these terrorist camps and were being indoctrinated, trained, and used in hostilities. Children as young as 7, 8, 9, 10 years old. And when we went there, surprise, they were not recruited, they were not enlisted, they were not abducted. They were the children, the sons of the leaders and others. So how can we qualify this crime of the parents? Growing up these children merely as soldiers. We say in Spanish, I don't know, because the translation will be very hard. We say that they are carne de cañón, like they only serve to put just to stop bullets. So this is the reality in most of the national jurisdictions. Now, at international level, perhaps now we are a little bit more sophisticated, but for the moment, I leave you with this interrogation. Of course, we have other cases when we prosecuted cases of crimes against humanity, but I will come later about this. Thank you.
Thank you very much for sharing this experience. Ms. Aubert, you, as soon as you co-authored the policy, and there are different principles that are enshrined in this policy. However, speaking about the protection, could you please elaborate a little bit more how children that should then be invited to the ICC, what exactly the ICC should do to protect them?
Yeah, thank you very much. So as I mentioned, the 2023 policy builds on the 2016 policy. Time passes, technology, things are evolving. And actually, I really would like to recommend, because yet the policy audience, objective was for the Office of the Prosecutor, but we're hearing a lot of domestic jurisdictions actually finding it very useful. So I'm just doing some advertisement here on it's useful for the international, but also for the domestics system. So yeah, to start, the policy really emphasizes how children are impacted by crimes, both directly, and I'm not going to list all of them, but you've heard about recruitment, sexual violence, torture, displacement, and so forth, but also indirectly through the witnessing of violence, or, for example, to long-term impact of losing access to education and health care. And it's on this framework that then the policy highlight key principles. And I have selected actually 6 that I thought that would be interesting for the discussion today. And I'll go over quite quickly because some of them we have already discussed. But it's just to have an idea of what are the key principles that should and can actually be useful when undertaking and trying to handling cases where children are involved. First, that child rights must be at the forefront of all actions and based on the best interest of the child. And as Kim was saying, that sounds like an easy concept. Actually, it's quite subtle, and the policy, I think, does a good job in trying to articulate that concept and how these include prioritizing children's safety, well-being, development, while balancing these in a manner that best serve the child's interest and right to protection, care, and justice. A second principle is around diversity and the fact that children's experience really vary depending on their personal characteristics. And obviously age and age disaggregation and analysis is essential, as much as gender, ethnicity, religion, where they live, and so forth. And really that the multidimensional aspect and identity of the diversity of experience needs to be addressed and analyzed and understood on an individual level. Third, the importance of taking a survivor-centered and trauma-informed approach, which is something that the Office of the Prosecutor is refining and defining more and more. And I think the prosecutor yesterday mentioned an upcoming new guidance and policy next year to really ensure the well-being of child survivor and how much this should be prioritized and include, how to provide them with need to heal as they participate in the justice process. Fourth, provide some useful recommendation on proactive engagement with children and some guidance, for example, on obtaining consent and involving them in the decision about their participation, yet also handling carefully the appropriate adult that will play a key role in case of a judicial process from analysis to investigation and prosecution. Fifth, it underlines collaboration and cooperation with external entities to really reinforce that the Office of the Prosecutor cannot work in silo, but really has to work with child victim and witnesses expert in the legal, medical, psychological, and that's really this collaboration and cooperation has to be increasing and consolidated. And finally, obviously, the concept, the principle of non-discrimination is really articulate and underline and as regardless of their background, so that they are being afforded the same protection. And it's easy in theory, but in practice, in conflict settings, really paying attention to special vulnerabilities of marginalized or disadvantaged group require an extra set of effort. And this is really important to clarify and provide guidance on how to apply that important principle as well. Thank you.
Thank you very much, Ms. Aubert. So we know we have some kind of now understanding what to expect, how the experience was at the ICTY on the national level. We know what exactly we need to concentrate on to protect the children. But then the question to the prosecutors and the judge, how important are the testimonies before the court? From the prosecutorial perspective and from the judicial perspective. Maybe we'll start with the prosecutor.
I think we discussed this morning very much how important it should be or would be. Reality is that for the ad hoc tribunals, of course, many children or young adults have been interviewed as victims and witnesses, but none of them. So by the time trial started, they were all above 18. So which means there have not been children testifying, even if the rules of procedures allowed it to happen. That if judges would be of the opinion that a child could give a meaningful testimony but would not really yet be in a position to understand what testifying under oath would be, that the testimony would still be entered into proceeding, but that the evidence would need to be corroborated, and the decision and the conviction could not only be based on the specific testimony. So it is obvious that if you look at the numbers of victims in the different conflicts, obviously children should have played a more important role. Let's see how the development at the ICC would be. But perhaps one word in this regard. I mentioned earlier how important the evidence on children victims was in relation to establishing intent. But we've also seen that our judges, in many cases, used the fact that they were children as victims as aggravating circumstances in order to get higher sentences, really very much explaining that the vulnerability and the targeting of the most precious part of our society was really an aggravating circumstance. We have this in many of our judgments, which I think shows very much how important at the end of the day the involvement of children as witnesses, but definitely evidence in relation to crimes against children was in prosecuting but also in sentencing.
Thank you very much. Turning to Judge, you mentioned also at the beginning that crimes against children are also some kind of crimes against, because they are damaging their project to life and future perspectives. And yesterday we have heard also the prosecutor's Hans mentioning that sometimes this simplistic explanation and testimonies can mean a lot and that they are important to hear. What is the judicial perspective on that?
Well, thank you. I must confess that I have contradictory feelings. Well, I'm thinking as a judge now, of course, but I have been for a very long time prosecutor. So I have these contradictory feelings when we are trying to use children in courtrooms, in judgments. We are perhaps sometimes instrumentalizing children. Of course, from the judicial point of view, it's wonderful if we can have victims, childs that are corroborating indeed intent or facts or whatever. But what about the victim? Because normally children are not only witnesses, they are victims first, and they come as witnesses. So it's very difficult because sometimes I wonder if we are re-traumatizing these children, we are re-victimizing these children, and it brings me to a very serious example that I had, for example, in Peru, in the many cases I had for crimes against humanity. One of the most famous cases in Peru was the Cabitos case, that it was about crimes against humanity, torture, rapes, murdering, etc., committed in a military headquarters in the highlands of Peru during the period of the conflict, non-international armed conflict, perpetrated in 1984-85. So the military used to organize riots and took persons, people, especially young people, and they were taken and put in some spaces in these military headquarters of Cabito. But among them, they used to bring children as well. And among the children, they used to bring girl children. And among the girl children, they used to bring children as young as 7 years old or 10 years old. So one of my victims and also witness was one of them, let's call her Maria. Maria was a girl that was conducted indeed to this military headquarters from a riot because the military didn't find their father and her brothers. So they conducted her, that was 10 years old, Maria, and her sister of 7 years old. And in the military headquarters, of course, she was a victim of rape, sexual violence against her, because they used to, that were the practices by then among the military. There's horrendous crime. Now, when 25 years later, almost 30 years, I was the prosecutor of this case, among numerous cases, I started to look for this person because she could tell us how horrible was that. She was called numerous times, she couldn't come, and finally, when we moved with the judges to the Highlands, in a courtroom to the Highlands, we managed to just to locate her, and she finally came. And when she came, some of the members of an NGO came and told me, she's outside, but she doesn't want to enter. She wants to talk to you. And when I went outside, and I met her, and I said, what happened? What happened is that she couldn't come before because she was now a married woman. Of course, she was an adult. And when her husband knew about these abuses, he repelled her. He expulsed her from her house, telling her, no, you are no longer my wife because you have been in the past a wife or a woman to the military. So she was terrible, terrible, traumatized, re-traumatized and in pain. And so for some seconds, we just embraced and cried together because, yes, prosecutors and judges also, we are human beings. And then I encouraged her to come inside to the courtroom and tell all the truth. And she encouraged me to make the right questions. And we did it. But we had to stop several times the hearing. Because the content of the witness, of the testimony was so intense that sometimes we couldn't even speak because her pain was reflected in her eyes. She couldn't speak sometimes. Her silence told more than her words. There was quite a huge experience. And on top of that, in that time, she allowed herself to remember something she was hiding from herself. That she kind of accepted to be raped because the military told her that if she stopped to cry, they wouldn't do the same to her little sister. And she kind of accepted. But then she discovered that the military also abused from the little girl of 7 years. So it was so intense. Then I was wondering to me, why I'm doing this? I'm re-traumatizing this poor woman. Of course, I asked psychological support in the moment of the testimony and after and whatever, but it was not enough. So this brings me to these special contradictory feelings. Yes, sometimes it's important, especially at the level of international crimes, to discover this atrocious reality, to bring children. But we need to be sure that this is absolutely necessary. Otherwise, I wouldn't recommend, because we need to take care of these people that have already been traumatized in the past. And we cannot continue pushing and pushing and delving into the same wound. Thank you very much.
Thank you very much. As you correctly mentioned, time flies, and children who were victimized as children are becoming adults, and they are living with this trauma. And time flies, as our panel time also flies. But I want also to mention, before opening the floor to the audience, Ms. von Wistinghausen, you are representing the victims also from Darfur, and especially the crimes that happened in the beginning of the 2000s. And children that were also in that case, they are already adults, they have their own children. What can you share from that perspective?
Yes, I said that none of the cases I've been involved really implicated children very much. And in the Abd al-Rahman case, it's the same, because it doesn't involve crimes that are deemed to specifically target children as a class. Unlike in Lubanga, Katanga, and Taganda, Putin, for example. So In my view, that's a relevant and important point that we could discuss, because even where the international crimes are not being prosecuted as a specific crime against children, the vulnerabilities, some English words are tickled, of children and the impact of the charged crimes on children, which we've talked about a lot about today, are subjects that are recognized, that are investigated, of course, and that are highlighted in the proceedings. For example, education, family, culture, future generations. But that's all theory. How does it really happen in the courtroom? I personally did not get the feeling that the Office of the Prosecutor in our case had any plan or conscious approach to eliciting child-specific evidence, and it was primarily something that we as the legal representatives of victims sought to do. For example, when during questioning of witnesses, we tried to highlight from one or two witnesses the fact that several young boys were among a group of men who had been detained and executed, but a few of them were underage, were children. Then we had this, as we get as victims' counsel, this small spot within the trial, the victims' case. We had 5 days. I could talk a lot longer about, the efficiency of such a short victims' case, but that's another story. So we were granted to call victims to present their views and concerns, and also one witness. And when you represent 1,500 victims, which also is a challenge per se, and again questionable of how efficient that is, you have to make a choice. So what is the message that in this short period of time you want to bring to the judges? And so and why am I saying this is because the aspect of the harm suffered by children, and specifically women, that hadn't played such a big role during the proceedings themselves, was something that we wanted to put at the focus. So what did we do? The child of the time, of course, now is a young man, right? So one of my clients is a young man who's now in his mid-end 20s, but he was a child at the time. So that was the first choice, to call him. He spoke to the judges in public under his own name. You can watch it on YouTube if you want, because obviously that was a really, really important space that he as an individual was given, and he could tell his own story of his family, the displacement, the ongoing displacement from one place to another, leaving the country to Kampala, now eventually being relocated or not relocated. He lives in Canada, I can say that. As I say, he spoke in public. So the whole aspect also of now living in a diaspora, right? I mean, so we could cover all these aspects that are specific in themselves, but told by this child who was now a man. And the other way we could bring in the transgenerational harm is through calling to women from 2 different refugee camps, one in Darfur, one in Chad, because many of my clients are in Chad as well. And these women are women's representatives in the camp, and at the same time, they have the children's issues, problems in their focus, and could tell us a lot about that, brought pictures that we could show the judges. They spoke a lot about, of course, the disastrous humanitarian situation no one talks about, the medical situation. The children don't go to school anymore at all since the new outbreak of the conflict in April 23. They are just left at their mercy because the mothers have to go and see how to earn some money somewhere in the fields. So the situation of the children, now of course second generation, is very difficult, and yeah, that was the way we chose how to put the children's issues at the heart of the victim's case, I would say. Of course, also in the trial brief. We wrote a trial brief. We are writing a final brief now, and there as well we gave statistics, how many were children at the time, and so on and so forth. And just lastly, because I know I'm getting to too passionate about what I'm speaking about. But one thing I would like to say, I don't see children being at the heart of the criminal proceedings at the ICC in the future. I know that this is maybe a nice aspiration, but I don't think it's going to happen. And I'm not sure I find it sensible, because I don't think that, be it in a national or an international jurisdiction, it's a good thing to have children as witnesses in a courtroom. There may be other means, like prior recorded testimonies, but that brings other problems, so fair trial rights that should be respected, and so on and so forth. So it has a lot of aspects, and I think that sometimes it's maybe not the courtrooms, but other avenues that have also been mentioned today that would help the children more than having this moment in the courtroom. And I'm really speaking about the trial phase, right?
Thank you very much. So as you can see, you can see their microphones, and you can ask your questions. Please, this is the moment that you can really address your questions to the experts here. Please, you can come to the microphone.
Hello? It is on. Hello. My name is Diane Amon. I'm a law professor and was name-checked very kindly by Véronique Aubert earlier. I preceded her as the Special Advisor for International Criminal Court Prosecutor Fatou Bensouda on children in and affected by armed conflict. And I just wanted to say a couple of things about the child witness issue that keeps coming up. I was a criminal defense practitioner in my national system in federal court for several years before going into academia. And I think sometimes we forget the justice process is challenging for everyone. And I think of in one of the first criminal cases, I was third chair in a money laundering trial in San Diego. It was very high profile. The husband of the mayor was on trial for money laundering. It took us 2 or 3 days to choose a jury in individual questioning in a witness box. And we had a break after one of these where a woman, perhaps in her late 50s, early 60s, was asked the questions, have you ever been a victim of a crime? Do you know anyone who's a police officer, etc.? I walked into the ladies' room and she was vomiting in one of the toilet stalls because that experience had been something she was not prepared for at all. And so I worry about the maternal paternalism of always saying children can never be witnesses without an acknowledgement that even for people who aren't traumatized, who are simply brought into a space they'd never been to before, we're pretty scary folks. And so that leads me to resist bright line divisions on this question. And we stated in the 2016 policy that children can be, and their national systems often are, reliable witnesses, and there should be no categorical bar. Now, does that mean that they should be front and center all the time? I actually disagree with that. The other thing that I wanted to mention, and then I will finish, is that in fact children have been witnesses in international criminal trials in this very building. There were 6 of them in one trial. The youngest one was 15. The eldest were 17, and they were talking about things that had happened to them as early as 10. And their testimony, in my view, from having read the transcripts in the Rouchat case, was among the most pivotal in that case. So it has been done. It can be done. Should it be done all the time? No, but I don't think we should automatically go in that direction. Thank you.
Thank you very much. Does anyone want to comment on the statement? All right, then please. Yeah, no, just commenting. No comment? Okay, please.
Thank you very much for inviting me to this extremely, I would say, poignant occasion and forum. I'm from Malaysia. My name is Rahman Shamsuddin. I'm a Director of Advocacy to the Center of Human Rights and Research Advocacy. My partner, Encik Azriel Amin, has prosecuted for the Rohingya cases with the Myanmar perpetrators in absentia. And we are involved a lot in the stateless people, and especially the Rohingyas, the refugee Rohingyas. I'm very, when I hear your statements, I mean, the work that we do is the most depressing work. You know, interviewing people who are, who has gone through so much suffering, and the sad thing is, even if we achieve success in prosecuting, the win is asymmetric to what has happened. Millions get killed. The ones that get punished is probably 1 or 2. Case in point, Milosevic, for example. And probably Izbegovic. I'm sorry, it's just Milosevic and the other. Mladic, yeah. And in this courtroom itself, we have the Nazi criminals persecuted for millions, and only about 20 of them showed up, right? There must be something wrong here. Just is not balanced. So in Malaysia, we just did a declaration on the value of human life, the sanctity of value of human life, and we say that every human being, including us, every one of us here, is priceless. Every one of us does not deserve to be killed. And we have to get this mentality into every human being. And the future killers or genociders of the world has to understand every human being is precious. And especially children. Children are, you as a parent, you can't even imagine killing children. And here we have a future where children are being killed every day in front of your smartphone. In these hallowed halls, the people who plan to kill Anne Frank, right? They designed this whole process in the 1C conference. Reinhard Heydrich did it, even though Hitler and Himmler
I'm sorry.
I just have to say this, because the value of human life, that the declaration, I think, is important for us to put in the UN Declaration of Human Rights and the Convention of Children's Rights, because that comes first. There's no point talking about human rights if you don't care about human life.
I'm sorry. Okay, so there is no question.
The question is, what do you think about it?
Okay.
After being prosecutors for years.
All right.
No, I understand your frustration, right?
Okay.
After going through years
Thank you
of
very much.
prosecution.
Considering the amount of questions that we receive, we need to address it accordingly. So, Mr. Brammertz, you want to answer to that, please?
Yeah, I mean, accountability is one of the big challenges, right? I mean, we are now speaking for a number of days about the child victims and which place in the procedure, with kind of therapies, how to work with the family, who is considered as a victim, the direct victim who has been physically harmed, but also all those who have seen someone else being harmed. If we look at statistics, 70% of children, for example, in Rwanda, have seen others being killed. And so we have a lot of discussions about it. But as I said earlier, unfortunately, accountability remains a big problem, and there are a number of reasons for it. When I was federal chief prosecutor in Belgium, when there is one child abducted, you have immediately a task force with 50 police officers, you have helicopters going up, you have dogs helping you searching, and rightly so. It should be the #1 priority. If you look at the international level, look at international tribunals, the resources available are very small. I remember at my office when we started at the ICC in relation to the Lord Resistance Army, we had 4 investigators working on it, and you speak about thousands and thousands of victims. So it's also a call by the international community. What kind of international justice do you want to have? Is it an alibi international justice, or do you really want to have results? And then you have to put the resources in it. You know, I'm still in charge and dealing with a tribunal which was set up 30 years ago, right? I was in Kigali recently. I spoke with the Prosecutor General. There are still 1,000 outstanding arrest warrants in relation to genocidaires. We managed last year in May to get one of the main genocidaires, alleged genocidaires, arrested in South Africa. He's allegedly responsible for the killing of more than 2,000 women and children in a church in Nianje. Well, we are still waiting for him to be sent back. I'm just back from 3 weeks in the former Yugoslavia, in Croatia, Bosnia, Montenegro, Serbia. There are several hundreds of perpetrators for crimes committed in Bosnia-Herzegovina, including against children who are freely living in neighbor countries. And we have difficulties, even 30 years later, to have them arrested and prosecuted. And we speak about a region in the middle of Europe. So you can imagine how challenging accountability is if you look at the global perspective. So I don't want to be pessimistic, but as I said, you know, it's still a long, long way to make sure that our accountability is more efficient, hoping that a successful accountability will have perhaps one day some deterrence as an impact, which would be very beneficial for prevention.
You wanted also to respond?
Just a small comment. Interesting the comment of the colleague and also from Serge, but I would like to recall that international justice for these atrocious crimes is not only about accountability. Because processes and special, not only convictions, but special sentences had to do with also reparations and the purposes of sentencing. What is the purpose of sentencing in international crimes? Only revenge, only prevention, or something else? I would say it's something else, as I said it in my dissenting opinion in the sentencing of Ongwen appeal, which I presided over, because he was, in this case, the so-called victim perpetrator. He was a victim as a child. He was abducted at the age of 9 years old. He was not only enlisted, but indoctrinated, violently indoctrinated. He grew up in a very, very atrocious and violent environment, having as a model to Mr. Kony, the leader of the rebel group, and he was obliged, he was forced to participate in very violent and criminal activities, such as to have to eat, to be present while the other members of the group were killing people, and after there, these wounded people were opened by chest, and the hair was taken out, and they obliged to Mr. Ongwen to eat the palpitating heart. So what kind of damage could have had this kind of activities in the brain of Mr. Ongwen, in the formation of his personality, in the formation of her personal values? He was a victim as a child, exactly for the same reasons that my distinguished colleague Serge Brammertz just said, because he was not only regarding how pain was inflicted in others, but he was actually being forced to participate. Of course, nothing of this makes different his culpability, because the crimes he committed were crimes as an adult. And of course, it doesn't negate the right of victims to the other victims of the Mr. Ongwen crimes to be recognized and to be repaired, of course. But international justice, I would say, and with this I finish, is not only about revenge, is not only about prevention, but it's also about to be, if the justice is properly adjudicated, it meant to be the basis for reconciliation, for the reinstatement of the rule of law, and for basis for lasting processes of peace. Thank you.
Thank you very much. In order to make it fair also to our digital viewers, I will also take a question from my iPads that I have here. So, and the question goes to Ms. Aubert, relating in the light of positive complementarity. How does ICC support domestic prosecution of crimes against children? And then, Raina, please, I'm sorry for... Please.
I think I hope I understand well. I do see, Shelley, the sound is kind of interesting on the panel here. So yeah, I really think positive complementarity, and actually, as I was mentioning, I think there is so much to learn from the domestic expertise, and it just made me think. I had a conversation with my daughter last week. She's 16, actually just turned 17, and she said, "Okay, let's, I'm being raped. I live in Switzerland. As my mother, what would you do?" And I say, this is what I would do and do and do and do. And then she asked, if we were in Afghanistan or she started listing situation of armed conflict, and she said, what would you do in terms of international justice? And I say, probably nothing, because at the moment it's, will be too controversial, complex, sensitive, and so forth and so forth. So we started talking about domestic expertise. And when we launched the ICC policy in New York at the ISP, we had the prosecutor from Fiji on the panel, and she was extraordinary. Fiji you wouldn't expect, but this woman has built years and decades of expertise in investigating, prosecuting all a diverse range of crimes against children of all ages, and really sort of brought it to the forefront of some of the very complex cases. And yet this woman then was sitting and providing really wise in structure and very helpful recommendation, very concrete recommendation of how it had been done in Fiji, under her role as prosecutor and lawyer and so on. And I could see that a lot of her suggestion and recommendation really sort of started, bringing light to a lot of the colleagues that were actually interested in international justice and investigation and prosecution. So really in terms of, it's so important that there is learning being done by international justice mechanism from the domestic expertise and experiences. We're actually investigating, prosecuting crimes against children in many domestic jurisdictions actually does happen on a daily basis. Thank you.
Thank you very much. Raina, you wanted also to ask a question, right?
Thank you very much. And thank you for this extremely interesting panel, which caused me a lot of emotions, especially the example that Judge Ibáñez gave us about the complications when you call former victims or still victims as adults now to court. It reminded me of many own experiences. I had been living in Ayacucho in the years when these crimes happened, and I know many cases of a similar kind. And I was even called to witness 2 years ago before a Peruvian court in a case going back to the 80s in these circumstances, because these crimes have not yet been tried adequately, etc. But that's not my point here. I want to take your case and take away from it rape and sexual violence, because it happened many times also, and it happens in other countries. It has happened in Spain, in Ireland, that families are separated, children are taken away from their families for ideological reasons or reasons of social prejudice, etc. So it happened in Peru also. So my question to all of you, to you on the panel is there a special count to try these cases among the many crimes we have heard about against children, like rape, sexual violence, abduction, maltreatment, etc.? Is there a possibility to try and come to terms with the mere fact of forcefully separating families without any other crimes connected to it? Can you give examples, or is this what some people today call forced separation? Is this a field not yet entered into the realm of international criminal justice? Thank you.
Rainer, can you repeat the main question that you wanted to ask to everyone? Because I think because of the acoustic, we weren't really able to hear. If you just with one sentence.
I'm really sorry. The question is whether forcefully separate families, taking away children from their family, can be tried as a crime as such, without any other crimes connected to it, like the ones we have heard on the panel.
Okay, now it's clear. So it's about the separation of the family as a crime itself. Maybe as soon as we are coming to the end of the panel, I would consider that as a last question. And I would like ask to also the panelists, by answering to this question, also give what would you like to change, and what we have learned, and what would we like to change in this whole system that we have done so far, and in order to consider that for the future. So, but please, I would kindly ask you to be a little bit briefly in your answers to this question. I know it's very long answers. They are the long answers, but please, we'll start maybe from Ms. von Wistinghausen, please.
Yes, I'm not super sure I understood the question, so I'm happy to talk about it to you later. But as a crime against humanity, yes. The answer is yes. But I wasn't really sure if you were asking if it can be prosecuted on an international level in isolation, which then would be problematic, because at least if we speak about proceedings before the International Criminal Court, the court only prosecutes genocide, crimes against humanity, and war crimes in the crime of aggression. But of course, within these provisions, forceful separation equals. I mean, I couldn't tell you the exact alternative within the provisions of the crime against humanity, but I would say yes, but maybe the prosecutor knows better than I do. Yeah, maybe just to conclude, Gurgen, I mean, there's so much to say about all of this, but as I have mentioned before, I just think it makes sense to reflect on alternative avenues of putting children's rights and interests at the focus of what we are doing, and maybe to move away from specific charges and a specific trial. I'm not saying to have a child as a witness is a complete no-go. No, sometimes it will be a necessity, but I think that one has to be very cautious for the obvious reasons. The vulnerability of children, and of course, you know, every individual reacts differently. But I would be cautious.
Thank you, Mr. Brammertz, please.
Well, in relation to the question, I mean, in relation to the ICTY statute, there is only the forcible transferring children from one group to another, but it needs to take place in the genocidal context. So it's one of the elements in relation to genocide. So taking the children out in itself is not sufficient. It needs to be done with a genocidal intent to destroy partially or entirely a certain group for specific reasons. So as a standalone, we definitely don't have an international crime, but it is a specific element in the Rome Statute as well, but also ICTY. Your question, of course, would be for another conference. So just two very, very short comments for the future. Definitely, if we look back at the ICTY, ICTR, giving more visibility to specific crimes against children, I think, would have been a good thing to do, and probably will be better done by other tribunals. Also, when I speak with my colleagues, our focal point for women, for example, she would say, well, she doesn't like too much the expression women and girls. She really would prefer a much more clear separation between the two categories because of the obvious reason. So obviously, more visibility, more numbers, more attention in relation to this specific group of children to be in a better position to really determine the group as such and the amount of problems. And then definitely, I think we all agree, and it was discussed at the international tribunals, very much the definition of a victim was very much a person who was directly harmed, a direct victim. And I think we all agree, and science has very clearly established that the group of victims is much larger than those who are physically directly impacted, those who are seeing crimes committed, those who were affected psychologically in many, many different ways. So the notion of victim needs to be seen in a much, much broader sense than what we have seen traditionally in international tribunals. Of course, there are 1,000 other points I could mention, but that's for the next conference.
Thank you very much. Judge? Sorry.
Thank you very much. Well, to the question of Rainier, really, I think I also support some of the comments made by Serge, but I think that it could be considered a crime in itself, only it is not yet in the cold letter of the law. And it brings me to my first intervention. We have gaps of impunity here. We have lack of legal characterization of numerous behaviors, criminal behaviors against children and against families, of course. To just add a bit my participation here, I would like to tell you or to say that how can actually judiciary or practitioners, legal practitioners, make improvements in this kind of crimes, especially for judges? I would say from my personal experience that legal interpretations, judicial interpretation of the law has a lot of importance on this, especially when we have gaps in criminality, gaps of legal characterization, gaps on how we determine damage, etc., and etc. And in terms of the justice we adjudicate in the International Criminal Court, I would say as far as all the crimes under the jurisdiction of the court amount or entail grave violations of human rights, so we are obliged, not only because Article 21.3, but because the nature of the crimes, we are obliged when interpreting or applying the law to be consistent with international human rights. And there is where we have a real source for better interpretations, because we can recourse to the conventions on the protection of children, to the conventions of other human rights, etc., and etc. But also, I think, this is my personal view, of course the debate is open, and humbly think that these interpretations should be more inclusive and diverse, because we are judges coming from diverse parts of the world, so we have different points of view. Mm-hmm. So this is the reason, because we need to integrate all of these different views, and also embrace intersectional approaches, because the crimes and victims come from different realities. So we need to be consistent all the time with recognized international human rights. And to end, I would like just to remember, as the Peace Prize winner Malala Yousafzai said, when the whole world is silent, even one voice becomes powerful. Thank you.
That was powerful. Thank you very much. Ms. Aubert, please.
Yeah, I think conscious of time. I think I will leave my colleagues having answered the question. So I will just focus on one last message. And it's actually a plea to legal practitioners or those who actually tend to not make the differentiation between ensuring accountability, visibility for crimes against children in war, with interviewing children and having them sitting in a court through a horrific, long judicial process. These are two different things. There are many ways that investigation can be undertaken on crimes against and affecting children, through talking to the teachers, the doctors, the whole. A child doesn't live in solo; it lives in a social context. In most cases, with a whole social network around him or her or they, and therefore there is a lot of people that can be talked to without having to talk to the child directly, and there are a lot of information that can be gathered through media, technology, and so forth. And so really, let's differentiate and not conflate the importance of making crimes against children visible with putting children into a horrific, long, painful, and difficult judicial process, because these are two different things. And so really, what's interesting now, there are more and more tools that are being developed on how it is possible not to ignore the crime that are being committed in terms of conflict situation, how there are technology, methods, and possibility without re-traumatizing or putting anyone through a very challenging and, we all know, very difficult legal process sitting in a court. So let's not conflate, please. And thank you for the invitation. It's been fascinating. Thank you.
So we are coming to the end of this panel, and actually to the end of the day. Thank you very much for being with us. Thank you very much for our distinguished guests sharing their expertise. And with this, I also thank you for listening and also being patient with the time. With this, I pass over to Kiran back. Thank you very much.